5 seconds to go. Start. On the fateful day, accused persons armed with dangerous weapons and bombs attacked the deceased and the prosecution witnesses. Appellant heard bomb on deceased and he died on the spot, and others also heard bombs and prosecution witnesses suffered splinter injuries. The High Court upheld the acquittal of all the accused except the appellant and convicted the appellant under section 302. The High Court has not exercised the caution that was expected to while dealing with the judgment of acquittal by the trial court. High Court was not justified in interfering with the well considered judgment of the trial court. The judgment of the High Court is set aside and that of the trial court is restored. The well considered judgment of the trial court has been upset by the High Court, and in its judgment, the High Court relied on the complaint. There is hardly any consideration in the High Court's judgment, more particularly of the mix up of timings as regards the complaint. In the complaint, it is specifically alleged that the Telugu Desam party was led by the appellant. Both the parties had fought in connection with using the road, and the witness himself and his party people were accused in that case and were absconding. It is then suggested PW1 and other persons went to cart the paddy hay of RP, and while they were bundling the hay, the 16 accused persons came there, and the appellant A2, A3 were holding bombs in their hands. It was the appellant who heard a bomb on deceased. The said bomb exploded and deceased fell down and died on the spot. Then the others also started hurling the bombs. PW1 then refers to his being hacked by other accused persons with a hunting sickle and on the right knee with the spear. He then refers to an injury caused on his little finger because of the spear. He then refers to the police firing a gun. After that, he refers that all the injured came to the government hospital and were being treated. On seeing the evidence of PW1 in the light of evidence of PW14, head constable, and PW15, circle inspector, the falsity of his evidence becomes clear. Though in his examination in chief he claimed that all of them, along with the women folk, were taken in the tractor. The assessee, a cooperative society engaged in the business of providing credit facilities to its members and marketing their agricultural produce, invested the surplus funds in short term deposits with the banks and in government securities and earned interest thereon. The assessee showed the said interest income under the head income from business, but the assessing officer assessed it as income from other sources under section 56 and held that the assessee would not be entitled to deduction under section 80p 2a of the Income Tax Act. In the instant appeal filed by the assessee, the question for consideration before the court was whether the interest income earned by the assessee society on surplus funds invested in short term deposits would qualify for deduction as business income under section 80p 2A of the Income Tax Act 1961. Dismissing the appeals, the court held an income which is attributable to any of the activities specified in section 80p2 of the Income Tax Act 1961 would be eligible for deduction. In the instant case, the interest held not eligible for deduction under section 80p 2A is not the interest received from the business of the society, namely providing credit facilities to its members or marketing their agricultural produce. What is sought to be taxed under section 56 of the Act is the interest income arising on the surplus, which surplus was not required for business purposes and was invested in specified securities as investment. Assessee markets the produce of its members whose sale proceeds at times were retained by it. Since the fund created by such retention was not required immediately for business purposes, it was invested in specified securities. Such interest income would come in the category of income from other sources and therefore would be taxable under section 56 of the Act as rightly held by the assessing officer. The word income has been defined under section 224I of the Act to include profits and gains. This subsection is an inclusive provision. The Parliament has included specifically business profits into the definition of the word income. Therefore, the court is required to give a precise meaning to the words profits and gains of business mentioned in section 80p2 of the Act. In the instant case, assessee society regularly invests funds not required for business purposes. Interest on such investments cannot fall within the meaning of the expression profits and gains of business. Stop.